2022, the environment. Okay, first idea from 2022. The most significant achievement of modern law in India is the constitutionalization of environmental problems by the Supreme Court. Big statement. What's constitutionalization really mean here?
Well, it's quite a powerful concept. Essentially, the Supreme Court linked protecting the environment directly to the Constitution itself, primarily to Article 21, the right to life.
Ah, so the logic is you can't really live if your environment is toxic.
Precisely. They basically said a healthy environment is fundamental to life. They also drew on Article 48A, which directs the state to protect the environment, and 51AG, a citizen's duty.
Right, so the court really stepped up. Were there specific cases that made this out?
Oh, definitely. Key milestones. You had Subhash Kumar v. State of Bihar, which explicitly said a pollution-free environment is part of Article 21.
Okay.
Then there were the landmark MC Mehta cases. These brought in big ideas like the polluter's pay principle.
You break it, you buy it.
Kind of, yeah. And the public trust doctrine. The idea that the government holds natural resources in trust for the public. And the Vellore Citizens Forum case pushed for sustainable development, balancing economy and environment.
That sounds great on paper, but I imagine making environmental protection a fundamental right has real-world impacts, maybe some friction.
Absolutely. It's a double-edged sword sometimes. It empowers citizens, which is huge. But it can lead to clashes with the government, accusations of, judicial overreach or creating extra red tape.
Slowing things down.
Yeah, development projects can get delayed. And sometimes compensation processes through the National Green Tribunal, the NGT, can be slow too. It really makes you think, doesn't it? Does giving it this fundamental right status strengthen the law or just make things slower?
That's a constant tension. Okay, let's shift gears slightly. Still 2022, but about limits on rights. The right of movement and residence throughout India is freely available, but these rights are not absolute. Let's unpack that.
So this right comes from Article 19.1. Super important. It's only for Indian citizens. And like most fundamental rights in India, it's not unlimited. There are reasonable restrictions.
Okay, reasonable restrictions. What kind?
Well, a major one is protecting the interest of scheduled tribes, especially in designated areas under the 5th and 6th schedules. The idea is to protect their culture, their land, prevent exploitation.
That makes sense. What else?
Public health and morals. That's another ground. Think about restrictions on movement during.
Like the COVID pandemic. That's a very clear example.
Exactly. Public health emergency. Also, sometimes restrictions for security reasons, like needing an interline permit for certain border areas.
Right.
The main goal of these restrictions isn't just to limit people, it's to balance that individual freedom with broader societal needs, protecting vulnerable groups, public health, general order.
Okay, let's jump into some comparisons. Another 2022 question. Critically examine the procedures for electing the presidents of India and France. How do they stack up?
Well, they're fundamentally different systems, reflecting different roles. France has a semi-presidential system. Their president is powerful, a real executive figure.
Directly elected.
Right. Yes, directly by the people in a two-round system. Ensures the winner gets over 50% support, a strong mandate. But getting on the ballot itself is tough. You need 500 nominations from elected officials.
Okay, high bar to enter.
And India.
India's president is more of a ceremonial head of state meant to be above party politics, so the election is indirect.
By an electoral college. That's right. Elected members of parliament and state legislatures. And they use a system called proportional representation by single transferable vote, or STV.
Ah, STV. That sounds complicated.
It is a bit complex to explain simply. Voters rank candidates. If no one gets 50% plus one vote initially, the candidate with the fewest votes is eliminated, and their votes are transferred based on the second preferences and so on until someone reaches the majority. Plus, the value of each MLA's vote varies depending on the state's population.
So, France, direct mandate, powerful president, but hard to even run. India, indirect elections, ceremonial president, complex voting system few really understand.
That captures the core difference, yeah. One emphasizes popular legitimacy for power. The other emphasizes consensus for a unifying figure.
Let's dig deeper into the philosophy, a 2021 question. Constitutional morality is rooted in the Constitution itself. Explain this doctrine using relevant judicial decisions. What exactly is constitutional morality?
It's a fascinating idea. Think of it as the spirit of the Constitution. Dr. Ambedkar talked about it. He saw it as a way to coordinate conflicting interests in society peacefully. It's the underlying ethic that makes the rules work.
So it's not just the black letter law, but the values behind it.
Exactly. And you can see it embedded throughout the Constitution. The
Right.
preambles talk of justice, liberty, equality, fraternity, the fundamental rights themselves, even the directive principles guiding the state, and the checks and balances between institutions.
Okay, it's baked in. But when do courts actually bring it up?
Usually in really tough cases, where established social norms clash with constitutional values. The big examples are cases like Nas Foundation and later Nafte Singh Johar.
The LGBTQI rights cases.
Yes, the court invoked constitutional morality to uphold individual dignity and equality against Section 377, which criminalized homosexuality. It said societal views couldn't override fundamental rights.
Any others?
Oh, yes. The Puttaswamy right to privacy case heavily relied on it. Even the contentious Sabarimala Temple entry case involved debates about constitutional morality versus religious practice, particularly regarding equality and non-discrimination. It's a tool the judiciary uses to ensure the Constitution's progressive vision prevails.
Sticking with comparisons for a moment, a 2019 question asks, what can France learn from India's approach to secularism? We just talked France. How do they differ here?
It's a stark contrast. France practices laïcité, strict separation. Religion is kept firmly out of the public sphere. No religious symbols in state schools, no state funding for religious groups. Very clear boundary.
And India's model.
India's is often called principled distance. The state doesn't have an official religion, it's neutral. But crucially, it maintains a respectful distance from all religions and can engage positively with them.
Positively, like how?
Well, the state can intervene for social reform even within religious communities. Think about the law against instant triple talaq. That involved reforming a personal law practice.
Yeah.
Unthinkable in the French model.
So the lesson for France might be what? More flexibility?
Perhaps. India's model allows for protecting minority rights, specifically Articles 29 and 30 guarantee cultural and educational rights. It tries to foster respect for all religions and allows public expression of faith and culture while still being secular. It's about managing diversity, not erasing it from public life.
Let's look at equality now. Question from 2021. Analyze the distinguishing features of equality in the U.S. and Indian constitutions. How do these two big democracies approach it?
There are overlaps, but key differences. The U.S. 14th Amendment focuses on equal protection of the laws. India's Article 14 includes equality before law and equal protection of the laws. But India goes further, explicitly allowing for affirmative action or reservations.
Under Articles 15 and 16, right,
Yeah.
to address historical discrimination.
It's built into the text as a way to achieve substantive equality, not just formal equality. The U.S. approach to affirmative action has been more, let's say, judicially contested over time.
Any other Indian specificities?
Yeah, the directive principles, like Article 39 aiming for equal pay for equal work, show a commitment to social and economic equality. And Article 17, abolishing untouchability, was a direct strike against a specific, deeply ingrained social hierarchy. The U.S. Constitution originally didn't tackle racism so directly in its text.
So both aim for equality, but India's constitution seems more explicitly designed to remedy specific historical injustices.
I think that's a fair way to put it. Both backed by strong courts, but with different textual emphasis.
Now, a topic that's always relevant in India, the balance of power between the center and states. Question from 2020. The Indian constitution shows centralizing tendencies to maintain unity. Explain this using the Epidemic Diseases Act, Disaster Management Act, and the Farm Acts.
Well, the Constitution definitely has a unitary bias, partly a legacy of partition. There are built-in features favoring the center, the extensive union list of subjects, emergency powers, the governor's role, all India services, control over major finances.
But this question points to specific laws. How do they show this centralizing tendency, especially in crises?
Right. Take the Epidemic Diseases Act of 1897. It's old, but it allows the center during an epidemic to issue directives that override state regulations. Very powerful.
And the Disaster Management Act.
Similar central control. The Act of 2005 creates the National Disaster Management Authority, chaired by the PM. It gives the center significant power to direct states and manage resources during national disasters.
Okay, clear centralization in emergencies. What about the Farm Acts? That wasn't quite an emergency situation in the same way.
True, but it showed the center legislating heavily in agriculture, which is normally a stateless subject. The acts aim to create a national market, effectively bypassing or weakening the state-level mandas or APMCs. This caused huge pushback from states and farmers, arguing it undermined federalism.
It really highlights that tension. As the Sarkaria Commission famously warned, too much centralization can lead to blood pressure at the center and anemia at the states.
A very apt quote. Finding that balance is crucial. And it raises a question for you listening. In a major crisis, should the center always have the final say for the sake of unity?
Food for thought. Okay, next, from 2020, what steps are needed to make a commission constitutional? And would giving the National Commission for Women, NCW, constitutional status ensure greater gender justice?
Making something constitutional isn't simple. It usually requires a formal constitutional amendment bill passed under Article 368.
Which needs special majorities in Parliament.
Yes, typically a two-thirds majority in both houses present and voting, and a majority of the total membership. And importantly, if the amendment affects the federal structure distribution of powers, for example, it also needs ratification by at least half of the state legislatures.
Okay, quite a high bar. So why bother for a body like the NCW? What's the upside?
Well, constitutional status gives a body significantly more weight. It often gets powers similar to a civil court summoning witnesses, examining evidence. It guarantees its independence, secures its funding, and generally gives it more institutional heft and permanence.
But does that automatically translate to more power or effectiveness? We've seen other constitutional bodies, haven't we?
That's the crucial caveat. Look at the National Commission for Backward Classes in CBC. It got constitutional status, but its role often remains primarily advisory. Political will, adequate funding, and whether its recommendations are made binding are just as important. So constitutionality helps, it strengthens the institution, but it's not a magic bullet for effectiveness on its own.
Right. Implementation matters. Let's do another comparison. Judiciary this time, 2020 again. India and UK judicial systems seem to be converging and diverging. Highlight key points.
Okay, there's definitely shared DNA. Both systems are built on the rule of law. Both follow the doctrine of binding precedent stare decisis. Higher courts bind lower courts.
And they have similar structures.
Broadly, yes.
Yeah.
A hierarchy of courts. Both recognize the importance of judicial review, although its scope differs. And they're converging in modern practices, too, using technology, alternative dispute resolution, providing legal aid.
So where's the divergence?
The fundamental difference lies in sovereignty. India has constitutional supremacy. The Constitution is supreme, and the judiciary can strike down laws violating it. The UK has parliamentary supremacy. Parliament is sovereign, and courts generally cannot invalidate primary legislation passed by Parliament. That's a huge difference.
Any other key differences?
Well, India has a single integrated judicial system, while the UK has different systems within it. India abolished jury trials for most cases back in the 1960s. They remain in the UK, and the process for appointing judges also differs significantly.
Okay, last one for this segment, a really fundamental one from 2019. Parliament's power to amend the Constitution is limited, not absolute. Explain if Parliament, under Article 368, can destroy the basic structure by expanding its own amending power.
This goes right to the core of India's constitutional identity. Article 368 gives Parliament the power to amend, but the Supreme Court, in the landmark Kesavanavadhi case in 1973, laid down the basic structure doctrine.
The idea that some things just can't be changed.
Exactly. The court said Parliament can amend, yes, but it cannot alter or destroy the fundamental, essential features, the basic structure of the Constitution. Things like democracy, secularism, federalism, judicial review, the core of fundamental rights.
And subsequent cases reinforce this.
Oh, yes. The Minerva Mills case in 1980 struck down amendments that tried to give Parliament unlimited amending power, explicitly saying limited amending power is itself part of the basic structure. The Kumar case confirmed judicial review is basic structure.
So the answer to the question is a clear no. Parliament cannot use Article 368 to grant itself the power to destroy the basic structure.
So that's the established position. The power to amend is not the power to rewrite the Constitution's soul. That limitation is fundamental.
All right, final stretch. Let's look at two giants. 2018 question. India and USA are two large democracies. Examine the basic tenets their political systems are based on. What do they share?
They share quite a lot at the foundational level. Both have written constitutions. Both guarantee fundamental rights, Bill of Rights in the U.S., fundamental rights in India. Both are federal systems, uphold the rule of law, believe in separation of powers, and have an independent judiciary.
It sounds very similar, but the structures diverge quite a bit, don't they?
They do, in significant ways. A key difference is federal structure. The U.S. is often called an indestructible union of indestructible states. States have strong protections. India, under Article 3, is an indestructible union of destructible states. The center can alter state boundaries.
That's a major difference. What else?
The judicial system. The U.S. has dual courts, federal and state. India has a single, integrated judiciary from bottom to top. Also, representation in the upper house. The U.S. Senate gives 2 seats per state, regardless of size. India's Rajya Sabha has representation based roughly on population, and generally the U.S. Constitution is considered harder to amend than India's.
Okay, now for a right that feels very modern. Question from 2017. Examine the scope of fundamental rights after the Supreme Court's judgment on the right to privacy.
This revolves entirely around the K.S. Puttaswamy judgment from 2017, a landmark decision. The absolute key takeaway: the Supreme Court declared right to privacy is a fundamental right.
Not just a regular right, but fundamental. Under which article?
Under Article 21, the right to life and personal liberty, the court said privacy is intrinsic to living a life with dignity.
How did that change things? What's the scope now?
It massively expanded the understanding of Article 1. It confirmed protection against state intrusion, but also acknowledged the need for protection against non-state actors, particularly concerning data. But it's not absolute.
Right, the threefold test.
Exactly. Any state intrusion into privacy must pass a strict test. It needs a legal basis, legality, must serve a legitimate state aim, necessity, and the intrusion must be proportionate to the objective, proportionality. This ruling has had huge implications for everything from data protection to LGBTQI rights.
Okay, our final topic. The extreme measure. Question from 2018. Under what circumstances can a financial emergency be proclaimed by the president? What are the consequences?
This is Article 360. It's reserved for truly dire situations. The president can proclaim it if they are satisfied that India's financial stability or credit, or that of any part of the country, is threatened.
A pretty high threshold. Does it need Parliament's okay?
Yes, it must be approved by both houses of Parliament within 2 months. If it is, it can continue indefinitely until revoked, but needs periodic parliamentary approval.
And if it is declared, what happens? What are the powers?
The consequences are sweeping. The center gains almost complete control over state finances. It can issue directions to any state on financial matters.
Including salaries.
Yes, critically, salaries and allowances of state government employees and even judges of the high courts and the Supreme Court can be reduced. All money bills passed by state legislatures might have to be reserved for the president's consideration.
Wow, that's drastic centralization of financial power.
It really is the ultimate financial emergency tool, designed for an absolute crisis. And it's worth noting, perhaps thankfully, despite various economic challenges over the decades, a financial emergency under Article 360 has never actually been proclaimed in India. #outro.
Okay, that was quite a journey through some core constitutional issues. Let's quickly recap for everyone listening, help lock it in. We saw the judiciary carve out environmental rights under the right to life.
But also the necessary restrictions on movement to protect specific communities.
We compared India's indirect, consensus-based presidential election to France's direct, mandate-driven one.
And explored that deep concept of constitutional morality, the Constitution's guiding spirit.
We contrasted India's principle-distance secularism with France's strict separation.
And saw how India's approach to equality explicitly includes affirmative action, unlike the U.S. initial framework.
We looked at the center's power grab during crises via specific acts.
Discussed the pros and cons of giving commissions constitutional status.
Highlighted the crucial difference between India's constitutional supremacy and the UK's parliamentary supremacy.
And reaffirmed that Parliament's power to amend is limited by the unshakable basic structure doctrine. Plus, the huge impact of the right to privacy ruling.
The big picture seems to be, as you said, adaptation. India borrows concepts but makes them uniquely Indian.
Absolutely. Whether it's the basic structure or its model of secularism, the Constitution proves flexible and responsive. That's its strength.
Which brings us back to that centralizing tendency we discussed. Thinking about those crisis laws, the Epidemic Act, Disaster Management Act, it leaves a question for you to ponder. Where should the line be? How much power should the center have to ensure national unity versus the need to respect state autonomy? Something to think about after this deep dive.